Hi, I'm Anna Denton-Jones, and in today's session I wanted to talk about resignations and heat of the moment resignations in particular. So where perhaps there's been a bit of a blow-up, argument with a manager, some kind of altercation, and then the person hands their notice in. There's recently been an Employment Appeal Tribunal decision in relation to this kind of resignation, and they've summarised quite helpfully the position of the law, so I thought I would explain what that is. The first thing to say is that once somebody has given in notice of their resignation, they can't retract it and assume that the employer is going to go along with that. The law is clear that once notice of resignation has been given, then it's only if the employer agrees to allow the person to retract it, maybe change that notice to a different time frame or something like that. It's got to be by agreement of the parties. It can't be imposed by the person who's resigned. When it comes to looking at the sort of heat of the moment type resignations, then the courts are guided to look very much at all the circumstances of the case. It's going to be a decision made on the facts, obviously, of what has happened, but they will deploy a concept that's quite common in the law of a reasonable bystander. So if the sort of average man in the street, they quite often talk about the man on the Clapham omnibus, which is a bit of an old-fashioned expression now, but the idea being, just an ordinary citizen, if they found out about the scenario that we were talking about, what would their interpretation be of what was said, and perhaps hand gestures, slamming of doors, or whatever else went on in the particular scenario. So they will look at everything objectively, trying to have that kind of an approach to it, rather than perhaps listening to, a line manager who's saying, well, I interpreted their behaviour in this way, or I took what they said to mean this. So it is that reasonable bystander rather than somebody's subjective interpretation of events. The other thing that they are going to be looking for is whether, if somebody has expressed, as people sometimes do, an intention to resign, but maybe in the future talking about it in future tense, they'd want to understand that there was something clear that was said or done that made it the case that they've actually done it now, rather than talking about, well, I might do this in the future, or I might do that, if that makes sense. So they're looking for them to have really intended it, essentially, that they meant it seriously, that it was a conscious, rational decision, rather than, as the expression suggests, something in the heat of the moment. And the judges are quite generous to the employee who blows up, says the first thing that enters their head when the red mist has descended, but then quite quickly comes back to the employer and says, I didn't mean it, I overreacted, my head wasn't in the right place. So obviously that's a question of degree as to how quickly somebody does that. But where in a reasonable amount of time, maybe the next day, maybe Monday morning if it was on a Friday, the person comes back and communicates that that was the case, they would expect you to accept that it was a blip, rather than say, oh no, we've accepted your resignation now, you're off. So do be careful about heat of the moment resignations. Don't act too hastily. Do look at it in the cold light of day, when perhaps emotions have dimmed following whatever altercation or row has happened, and think about how that bystander might look at the situation before you act, rather than yourselves acting in the heat of the moment. I hope that makes sense. If you've got any questions, do let me know. It's adenton@refreshinglawltd.co.uk. Thank you very much.